Unit title. This is pretty much the same as stratum estate, including the difference in fee simple and leasehold, that being a fee simple unit or flat title you will own the unit or flat as opposed to lease it. But it is not exactly the same. Recent efforts have been made to upgrade legislations pertaining to the Unit Titles Act, and it may not be enough, as this act seems to only affect properties that have more than 3 units. So it might well be that if you own a flat or unit where there are 3 or less than 3 units, you may not be as legally obliged to form a body corporate as most folk assume, in my own personal opinion. Nonetheless, generally you share in common areas, much as you would with a stratum estate, but all owners lease each other's unit to each other, essentially nullifying the need to pay each other. This is the complicated bit. When the properties were first developed, each purchaser paid the other a set one-off payment, usually a nominal fee, say 10 cents, to lease their unit from each other for a set term, usually 999 years, which in legal terms practically means forever. So when you buy into or off someone that has one of the units, you are getting what is an equal share in fee simple land that is however subject to a 999-year lease by each owner on each other owner. This is also referred to as a cross lease. In a cross lease situation, it can be very difficult to make further improvements to your unit or the land, because if you want to do so, you will need the approval of all the other unit owners, and it is best to get this in writing, as verbal approval does not carry much legal clout these days. If you are or have bought into a block of units where there are 3 or less units, you may have more rights to certain things, as the current Unit Titles Act may not affect you. In particular, you may not be bound by the law into forming a body corp. This aside, as a unit owner, you will be an equal shareholder in a body corp and will share in the upkeep and maintenance of common areas. If you are considering purchasing a unit or flat, choose wisely, because some units or flats have better features depending on how their plan is laid out. For example, some units may have their own garage and drive, whilst others may not. Furthermore, some may have larger private zones or gardens than others, yet supposedly all are equal. Be aware also that it only takes one rowdy to ruin what might otherwise have been a nice holding. Leasehold property for private non-commercial use. Loosely, in my own personal opinion, some leasehold property tends to be by or around or near rivers, lakes, oceans, sea or mountainous areas, all sharing the same common theme. They are bounded by an attraction of some sort. Beware, for it is usually this attraction that blinds folk into thinking they are getting more than what they bargained for. These properties are often marketed near the end of a lease term. They are usually not owned by the seller, rather the seller usually has first right of renewal of the lease. Note, if the seller owned the property, it most likely would be very expensive to buy outright, and the title would be fee simple. Note, many folk have stumbled and fallen not understanding what the lease actually entitles one to, and it's basically this. A leaseholder is entitled to use the property according to the terms of the lease. The owner of the property, usually but not always a trust or corporation or other entity or person, owns the land. Be aware also that a current leaseholder may not have the authority to sell off the remaining term of their lease without the consent of their landlord, whom is the landowner or represents the landowner. In order to do this, the lease must be reassigned, and this may not, in some cases, be possible, as the terms of the lease might prohibit such. Okay, example. So you see a nice batch by Lake blah blah, and it's advertised for sale for 20,000, and you think, wow, what a bargain, because a batch down the road sharing the same view is for sale for well over 600,000. You need to ask the real estate agent if it's leasehold, and if it is, be aware that you will be buying the batch that's on the land, not the land. You will be paying rent to live on the land as part of your lease, usually annually or quarterly, and if you don't have a right of renewal when the lease terms expires, you may have to pay for the removal of the batch or forfeit it to the landlord being the representative of or actual property owner. So be very careful when entering into a lease. Remember also that once you become a leaseholder, it can be very difficult to reassign a lease to someone else. In short, leasing the land is like renting it but owning the batch or house on it. At the end of the term you do not own the land and may have to remove or forfeit any improvements. Seriously seek legal advice before entering into any lease. Many folk have been burned because they did not fully understand what they were buying into. Also ensure that the person offering the lease is not in arrears with their payments, as in this case they may be in breach of the terms of their lease and have nothing to sell. Contact the owner or landlord and seek further information before making any payment. Māori land. All Māori land is subject to the Te Ture Whenua Act 1993 and as such is not as alienable as general land. This is due partially to the fact that most Māori land is communally held in a customary-like manner. This should not be confused with customary land. Generally speaking, the only Māori that would be able to convert these types of title to fee simple would be single owners or a group of owners that have agreed to alienate their holdings. Alienation can only be done through the Māori Land Court, and only if the Māori Land Court judge is satisfied that all the specific legislative requirements have been met. Then the title will be released and the land in question will become as marketable as the title the judge places on it, which in most cases will be in accordance with the requests of the Māori owners or shareholders. A Māori landowner or legislative majority of shareholders in Māori land are the only folk capable of alienating Māori land, and only if they singularly or collectively, whatever the particular case may be, are able to meet the stringent requirements laid out in the Te Ture Whenua Act 1993. Trustees do not have the power to dispose of any Māori land unless they have the consent of actual owners and or shareholders. Also, generally, only shareholders in a particular Māori land block may buy out other shareholders in the same block. In short, if you are offered Māori land, then your best bet is to ask the offerer to convert the land title before expressing any interest. The Māori Land Court has wide sweeping powers over Māori land and does not look favourably upon those that seek to circumvent its processes. Rent to buy. In my own personal opinion, again be very careful and know what you are getting into. As in a lot of rent to buy schemes, only a small fraction of the rent goes into buying the property every week, and you might not live long enough to pay it off. The concept is that by making regular weekly payments that you will be able to eventually seek independent finance and thus purchase the property and pay a mortgage off. Consult with a lawyer and have them explain the terms and implications. Cheaper ways of investing in real estate. Sometimes councils will have abandoned land for sale, usually by tender. If so, you ask them to forward the tender document and submit your offer. This usually requires a refundable deposit to show your genuine interest, which is usually returned to you if you aren't a successful tender, but the terms may vary. Buying a share or interest in a friend or relative's property or getting together with the same to buy a property